Hello, my name is Dan Yomar, and today I'm going to be talking about defending claims by your former employer against you for breaches of non-competes and non-solicitation agreements. Non-competition agreements are an agreement upon which you've agreed that after you leave your employer for a particular time period, you're not going to work for somebody in that industry within a certain geographical area. Non-solicitation agreements, on the other hand, are more narrow than that. They generally say that after you leave the employer, you're not going to be soliciting customers. It can also state that it's not going to solicit employees, but usually in the litigation it's dealing with you soliciting customers. The courts will look at both of those and only narrowly construe them to protect the legitimate business interests of the employer. Two such business interests that the courts have recognized is protecting confidential proprietary information and goodwill. So in those situations, the employer has some right to enforce those. First, as to the non-competition agreements, if you're a new employee and being told that you're going to be signing a non-competition agreement, the employer just saying you're going to be signing a non-competition agreement, putting it into the letter for you to be hired, isn't good enough. They have to actually give it to you before you accept that job. So before you decide to leave the other job that you had and take this new job, you have to actually have a copy of the non-compete. That's part of the law in New Hampshire to be enforced. I also will mention quickly that doctors are not allowed to have non-competition agreements in New Hampshire, but nurses, physician assistants, nurse practitioners can have those types of non-competes, and frankly I see those in the industry. The confidentiality, protecting for that, courts will generally consider protecting confidentiality as similar to it being protecting against theft. If you have trade secrets, if you have confidential information, there's also a Uniform Trade Secret Act, and the Uniform Trade Secret Act will also protect, even if there isn't an agreement signed. So confidentiality is something that's very important. Goodwill comes about with what's really necessary to protect the legitimate business interests of the goodwill of the employer. And in that situation, that's really protecting if I am an employee and I'm working for Hamlin Carrigan, lawyers are not allowed to have non-competes, but let me use that example anyway. Hamlin Carrigan is selling software for companies. And if I am working for that company for a while and then I'm working with a customer, when I leave, my ability to take that business away from Hamlin Carrigan and work for that customer and take that customer with me is enhanced because of that relationship. And a period of time to prevent that from happening is considered reasonable. So a non-solicitation agreement that perhaps is for a year or so could generally be considered reasonable. But one that says you can't work in the industry for a particular period of time in that field of selling software or with a geographical area is going to be tough to enforce. The situations where I see that is enforced is when you're stealing stuff. You're taking the confidential proprietary information. Maybe you're taking customer lists, maybe you're taking other information. In that situation, judges are more likely to say you can't work in this industry for a particular period of time, we're going to enforce that. But generally those non-competition agreements are not favored. Some circumstances you might also have a non-solicitation, non-competition agreement that is so broad by its very terms that they won't even try to narrowly construe it, meaning that if you have a non-competition agreement that says you're not going to work in this industry for 1 year within 5 miles of this place, the court may very well say, we're going to restrict that down to only you can't solicit or accept clients that you did work with for that 1 year, instead of saying you can't work in this industry. But by way of example, if you want to say you can't work in this industry for 5 years for 50 miles, and I've actually seen that particularly in the medical field where they attempt to do that with nurses and some physician assistants. In that situation, it's likely to be found to be bad faith. And in that, because really what that is an ability, attempt by the employer to try to prevent that employee from leaving. You're going to take what we give you because you have no option in there. That's should be considered to be in bad faith. Lastly, as far as the 1 year on a non-competition, when I've dealt with these in court, traditionally I'm thinking 1 year is the non-solicitation provision, but it could be in an industry to be 2 years. I've had arguments where I've argued successfully for group health insurance industry, where you're only seeing that customer once a year, that having 2 times of putting your new face in front of somebody is worth it, and the courts have agreed to that. So all of that is subject to a review by the court, of course, and they are fought aggressively. I've been on all the sides of this, the former employer, the new employer, and then the employee in the situation. Generally, the court will look at a claim by the former employer suing for breach of contract against the new employee and a wrongful interference with contractual relationship against the new employer. And the idea by the former employer is to hope that the new employer will fire the new employee. If you want to hear more about this or read more about this, you can look at my written blogs on our website of hamker.com. I also have radio podcasts from WFAA 1370 and FM 99.9, but the podcasts are right on our website at hamker.com. And you can give me a call at 883-5501. That's 603-883-5501. Thank you.